43223, the State of Ohio versus Ashley Fields. You are Ashley Fields?
Well, my name changed to Ashley Bailey, but
Again, I have no way of knowing that.
Okay,
Is that,
so yes.
are you were indicted under the name of Ashley Fields, is that you?
yes.
Ms. Fields, we are scheduled today for a pretrial conference. It's my understanding, and I just found out a few moments ago, that you declined the appointment of counsel.
Yes.
Why would you do that?
Because Jesus Christ has my back and I don't need counsel.
Have you ever, do you have any training in the law?
No.
You ever went to law school? You're not authorized to practice law in the state of Ohio, is that correct?
Correct.
Oh, you have a right to represent yourself, but you understand that here in this courtroom, we play by certain rules, and the rules are very specific, the rules of evidence and the rules of procedure. Do you understand what those rules are?
Yes.
Do you understand the rules of evidence and the rules of procedure?
Yes.
Because you understand that if you choose to represent yourself in this matter, you'll be held to the same standard, and I will enforce the rules equally against you as I do against the prosecutor. You understand that?
Yes.
You want to represent yourself.
Yes.
All right.
Your Honor, I'll just note that at her arraignment on Friday, I raised an issue of competency based on her statements to the court during arraignment. This had been originally set for a pretrial later in the month. Based on her statements at arraignment and my suggestion of competency, I believe Magistrate Bessel had emailed Ms. Yazel asking for a sooner date for the court to kind of evaluate that and determine what was appropriate moving forward.
I think that's probably a good idea, Ms. Fields. What do you say you go by now?
Bailey.
Why did you change your name to Bailey?
I got married in here.
In here?
Well, in the jail facility.
Who married you?
Robert Todd Bailey.
No. What authority figure married you?
Jesus.
All right, well, the court does not, the state of Ohio does not recognize that. And again, you know, you can throw out the name of Jesus. I personally am a believer, but that doesn't really change what you're facing here. And you seem to be taking this very, very lightly. So I am a little bit concerned. So I will order a competency evaluation, an allegation of what the underlying alleged facts are.
Yeah, she trespassed into Mr. Bailey's residence. She was found sitting at the dining room table in the victim's home. The victim explained that he arrived home to find his dog in the front yard with the front door open. He asked the defendant to leave after finding her inside. He does not know the defendant other than an interaction with his neighbor. I believe the defendant used to live with his neighbor, be in a relationship of some sort with his neighbor, but otherwise the victim does not have any relationship or knowledge of the defendant. Law enforcement that she does not know the victim other than living near him, and she again represented to the court on Friday that they had gotten married, which of course the victim says did not occur.
What I'm going to do is I'm going to find that you're indigent today for the purposes of retaining counsel, and I'm going to appoint Attorney Chloe Kirby. I'm going to appoint Ms. Kirby standby counsel. I am going to order a competency assessment, so someone will be over to the jail to speak with you. You do need to cooperate with them, okay?
Okay.
All right, anything else, Ms. Nicholson, we can do today?
No, Your Honor.
All right, very good. Thank you all.
Thank you. God bless you guys.
5 CR 43223, the State of Ohio versus Ashley Fields. Good afternoon, Ms. Fields.
You?
Are you Ms. Fields?
No.
All right. Ms. Fields is present in court. With last time we were here, Ms. Fields had indicated that she had changed her name due to a marriage. Is that why you're refusing to answer?
If you're speaking to Ashley Bailey, I can answer.
I'm speaking to you,
Who's you?
the defendant in this case.
Which is?
Okay, I'm not going to argue with you. Last time we were here, the court had basically, Suspante had done a suggestion of incompetency. I had appointed at that time Ms. Kirby who is present in court as standby counsel. Ms. Fields had indicated that she was going to be representing herself or something to that effect. Ms. Nicholson is here on behalf of the state of Ohio. The court has received a report from Dr. Ledgerwood. The date of the report is 2826. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor.
All right, Ms. Kirby, I know that you have not had contact with Ms. Fields. I know that I had originally appointed you as standby counsel, but based on this report and her pending finding of incompetency, she is not capable at this time of waiving her right to counsel. So do we have a stipulation to this report from the state?
Yes, Your Honor.
Ms. Kirby?
Yes, Your Honor.
All right, at this time then, the court will find that Ms. Fields is incompetent to stand trial, but restorable to competency in the statutory time period. The least restrictive placement for her restoration is at Summit. You'll prepare an entry for me?
Yes, that will include an alternative placement.
Very good. Anything else from the state?
Not at this
Ms.
time.
Kirby?
No, Your Honor.
All right, thank you, Deputy. That's all. 5 CR 43223, the state of Ohio versus Ashley Fields. Ms. Fields is before the court with her counsel, Ms. Kirby, Ms. Nicholson, on behalf of the state of Ohio. On the issue of competency, the court has received a report from Dr. Rose from Summit. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor.
Do we have a stipulation to the report?
Yes, Your Honor.
All right,
Yes,
at
Your
this
Honor.
time, then the court's going to find that the defendant is competent to stand trial, and that will be, report will be admitted as the court's exhibit. Mr. Goodyear, what are we doing beyond that?
Your Honor, it's my understanding the defendant will enter a plea of guilty as charged to count 1 in the indictment, trespass into habitation. In exchange for that plea, the state will dismiss count 2.
Ms. Kirby, is that accurate?
That's my understanding, Your Honor. Ms. Fields has reviewed the plea form, and I believe she understands what she is pleading guilty to.
Okay, Ms. Fields, you're telling me you're going to change your plea to count 1 of the indictment. Before we get to your change of plea, I am required to go over some things with you, okay?
Okay,
How old are you?
35.
How far did you go in school?
I dropped out in 12th grade.
Are you able to read and write?
Yes.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you in this case? Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Ms. Kirby?
Yes, ma'am. Sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on today?
No, sir.
I have in front of me a document. This document is called a change of plea. On the second page, on the line marked defendant, there appears a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with Ms. Kirby?
Yes, sir.
Do you feel comfortable that you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to 1 count of trespass in a habitation. As a felony of the 4th degree, that carries a maximum penalty of 18 months in prison and a maximum fine of $2,500. The prison term is not mandatory. Do you understand the maximum penalty?
Yes, sir.
Now, you're also subject to a discretionary period of post-release control, which means that if you are sent to prison when you are released, the Adult Parole Authority may supervise you for up to 2 years. If you violate that supervision, the Adult Parole Authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year, or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time you get sentenced to. Do you understand that?
Yes, sir.
But it's not mandatory that you're sent to prison. The court does have discretion to place you into community control, referred to as probation. And while on community control, you'll have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
You are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt. The jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and examine each of the state's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain silent At your trial, you cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've gone over?
Yes.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes, sir.
This is how you want to proceed.
Yes, sir.
Mr. Goodyear, could you read a statement of facts?
Yes, Your Honor. Your Honor, by the 6th day of December 2025, Warren County, State of Ohio, the defendant Ashley Fields did by force, stealth, or deception trespass in a permanent or temporary habitation of any person when any person other than an accomplice of the offender was present or likely to be present, excuse me, in violation of section 291112B of Ohio Revised Code.
Anything on those facts?
Nothing on the facts, Your Honor.
Ms. Fields, did you hear the statement that was read?
Yes, sir.
Do you admit and acknowledge that what he said is true?
Yes, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we discussed?
Yes, sir.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. I am going to order a pre-sentence investigation, Ms. Fields. Quite frankly, I don't know enough about you or your history to sentence you today. So I'm going to order that, and we'll come back in a few weeks and do sentencing at that time. Mr. Goodyear, is there anything else?
Judge, nothing else other than we'd ask that she be held in the meantime.
Ms. Kirby, you wish to be heard?
Yes, Your Honor, thank you. Ms. has been doing some research and has been talking to some people at Summit about some potential mental health facilities that she could be transferred to or engaged in the meantime. One of which is Nova Behavioral Health, and I believe that they have an inpatient component to their facility. We would just ask that Ms. Fields be able to participate in any assessments and see if there is a bed available that she would be able to be transferred to at Nova or any other facility. Ms. Fields is doing extremely well with her mental health, and I think that we can all see that from the last time that we were here in court. She does have an underlying substance abuse issue that she wishes to get professional treatment for. She tells me that she's never had the opportunity to get real inpatient treatment for substance abuse and mental health alike, and would like the opportunity to do that instead of sitting in the county jail. She understands that there would likely be an ankle monitor component to this and is willing to comply with any orders of the court.
I am going to decline that request at this time. As I said before, quite frankly, Ms. Fields, I don't know enough about you. I'm just kind of reviewing your prior criminal history, which is significant for someone who presents the way that you do. So I'm going to deny that request. I'm going to hold you in Warren County Jail pending sentencing. All right,
Thank you, Your Honor.
This courtroom hearing focused on Luana Santana Diaz, a defendant seeking intervention in lieu of conviction, ILC, after being charged in a check fraud case involving stolen restaurant checks. What made the hearing unusual was that the court was not simply deciding whether she qualified for treatment instead of conviction. The real issue was whether Diaz was actually willing to admit she committed the crime at all. The judge repeatedly stopped the hearing to make one thing crystal clear. ILC is not a way to take the deal while still claiming innocence. If Diaz wanted the benefit of treatment in place of conviction, she first had to stand in court and say, plainly and honestly, that she cashed a check she knew she should not have cashed. By the end of the hearing, after several confusing explanations and a lot of pressure from the judge, Diaz finally appeared ready to accept responsibility so she could pursue treatment and avoid a felony conviction. The hearing began in Warren County, Ohio, with Diaz present alongside her.